Good morning, everyone. It's Aisha Chidoway. I'm an immigration attorney here in Orlando, Florida, but I represent clients all over the United States and internationally for immigration matters. My phone number here is 407-995-6567. So today I want to talk about what happens when you get a divorce and you have a green card or a permanent residency card. So typically there are two types of permanent residencies that you can get when you get married. One is a conditional permanent residency, and a conditional permanent residency is given to people who have been married for less than 2 years. And that card is given for 2 years, and typically at the end of the second year, you need to file for a removal of that condition so that you can get a legal permanent residency, which is the 10-year legal permanent residency. So of course, a legal permanent residency is typically given to couples who have been married for more than 2 years when they get that green card, and there's no condition to theirs, and they have it for 10 years. So typically within the lifespan of their marriage, you're usually able to file for naturalization on the 3rd year, as long as you're married. So, of course, we know sometimes, we get into this marriages because we're in love, but we don't anticipate divorces or whatever happening, but it does happen. So, if you have a conditional permanent residency and your spouse has filed for divorce or you are getting a divorce, the options for you are that you would need to file a self-petition because you obviously cannot file jointly with your spouse anymore. So one of the things I highly recommend when you're in that situation is to hire an attorney who can advocate for you and basically write an affidavit or a brief for you, basically stating that you did enter this marriage in good faith, because the USCIS officers are going to be looking to make sure that you entered the marriage into good faith and you were not trying to circumvent the immigration system. Essentially, you were not trying to have a sham marriage, which as we know, this happens. So that's one way to get the condition removed, even though you've been divorced. And then, from a legal permanent residency side, if you get divorced before the 3rd year of having your green card, then you cannot naturalize until naturalization means becoming a United States citizen. You cannot naturalize until the 5th year of you being a green card holder. The reason why is that the United States gives benefit or preference to couples who have been married and stay together. So when you've been married and you stay together, you're able to naturalize within 3 years. But if you do get divorced within those 3 years of having that green card, you're going to have to wait till the 5th year. So you don't lose any of the legal permanent residency or green card benefits. It's just that you cannot apply for naturalization until the 5th year if you've been married. So there is still an option for you. So I hope this video has been helpful. As always, I'm an attorney, but not your attorney. This is for informational purposes only. Smash my like button, subscribe to my page, and I would love for you to share this video. Until next time, have a